Honorable Speaker, Mr. Michael Fair, is unwell and is unable to greet us today. Consequently, we invite the Deputy Speaker of the House, the Honorable Clifton Paul, to preside over today's sitting.
Good morning, honorable members. Let us pray. Guide, we beseech thee, Almighty God, members of this house, that they may wisely deliberate for the good of this country and for the glory of thy holy name. Honorable members, please join me in saying the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. Pray be seated.
Item 3, oath of allegiance or affirmation of a new member. Item 4, confirmation of minutes. Item 5, messages from the Governor General. Announcement by item 6, announcement by Mr. Deputy Speaker. Items.
Honorable members, as you are well aware, that we are without our speaker this morning, who is unwell, as the clerk has informed you. Also, too, we have excuse from the member for St. Andrews Northwest, who has a very serious problem. In fact, she has a member of relative who suddenly passed away sometime during the course of last night. So our heart goes out to our dear sister, and we may ask God to bring peace and consolation to her heart and to the hearts of the family members, relatives, and friends. Honorable members, today is no ordinary day. As you are well aware, it would have been 13 years ago when we were seriously ravaged by Hurricane Ivan. And today we are well aware of the fact of what is happening to our friends and neighbors in the Northern Caribbean. The destruction by Hurricane Irma. Honorable members, it is deep within our hearts, and we felt and we do feel the pain and the suffering of our northern neighbors, specifically the people of Antigua and Barbuda. Our heart goes out to these people, my honorable members, and let us all join and pray. We are a Christian nation, and we are asking all religious denominations to pray for our neighbors, our northern neighbors. We are aware of the fact, and we do know that our Prime Minister has been in constant contact with our CARICOM leaders, looking at ways and means how we can assess and how we can address and how we can assist our neighbors. NADMA has been communicating with SIDIMA as well to see what kind of support and assistance that we can render to our neighbors. We in Grenada as well, our different organizations, with the business places, we too are ready and willing to extend our deepest support and assistance to our neighbors. So I want us to stand and have a moment of silence for those who have been deceased by Irma during that passage, especially in Bermuda and the Virgin Islands. May the souls rest in peace. Amen.
Item 7, presentation of petitions. Item 8, presentation of papers and reports from select committees.
Leader of Government Business.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker would request that we push this item lower down the order paper after the motion is given to allow the staff to be able to distribute the documents that will be here. And at the same time, wonderful, Mr. Speaker, I would request that we amend the order of the portion for bills to take the Rehabilitation of Offenders Bill 2017, which, as we all know in the House, should have been presented at the last sitting, but the member for Carriacou and Petite Martinique had to leave, and so he was discommoded. So requesting that this be the number one bill to be taken at this sitting.
Request granted.
Item 9, unopposed private businesses. Item 10, questions. Item 11, urgent questions under the provisions of Standing Order number 20. Item 12, statements by ministers.
Honorable Member for St. George Northwest.
Mr. Deputy Speaker, following up from your comments, your statements earlier on as it relates to the anniversary of Ivan and of course the now present major disaster that have hit several of our Caribbean countries and neighbors. And in the context of my own chairmanship of CARICOM at this time, and of course remembering that Grenada faced with the anniversary of Ivan some 12 years, 13 years ago, major disaster that's now confronting other islands, that we as a country need to show our support to our brothers and sisters in those islands. I wanted to use the opportunity to make the following statement related to the present update on the situation there and what is being done and what we should be doing here in our country. Mr. Deputy Speaker, as the Northern Caribbean region continues to grapple with the effects of Hurricane Irma, and of course with the also falling up and his partner Jose. And as chairman of the Caribbean community, I have been in constant communication with the CARICOM Secretary General, Ambassador Owen LaRocque, and the OECS Director General and Chairman of the OECS, Prime Minister Chastity, and the Executive Director of the Caribbean Disaster Emergency Management Agency, CDEMA, Mr. Ronald Jackson. We are working together, Mr. Deputy Speaker, to ensure that the needs of the islands in the Hurricane Irma's path are addressed in a timely, efficient, and safe manner. Let me make it very clear, Mr. Deputy Speaker, that this is not just about countries of CARICOM. We must also support our brothers and sisters in the other affected places as well. St. Martin, for example, St. Croix, and we understand the Turks and Caicos, although we haven't had specific level of damages known at this particular time, but we must place all of them because they are our neighbors, and they also came to Grenada's aid when we were damaged in 2004. This massive storm, Mr. Deputy Speaker, has already claimed the lives, as you already mentioned, in many countries, and has inflicted severe damages to the infrastructure of those countries. Therefore, we want to extend condolences to the family of the deceased and the governments and peoples of those countries. It is almost impossible, Mr. Deputy Speaker, to assess the human cost of disasters such as these, because I could very much recall when we were struck and I was Prime Minister. It was not just about the physical damage, the psychological damage on myself, on the people of the country was quite strong. Mrs. Deputy Speaker, only yesterday we marked, as you pointed out, the 13th anniversary of Ivan. As a grouping, CARICOM through CDEMA, Mr. Deputy Speaker, has already taken a number of immediate steps in the last few days. Rapid needs assessment teams were organized for ready deployment to Anguilla, Antigua, the British Virgin Islands, Barbuda, the Turks and Caicos, and the Bahamas. The teams include water and sanitation specialists, communication personnel, health specialists, and fisheries and agricultural specialists. CDEMA at the same time mobilized personnel and resources for those islands, including the procurement of additional emergency items identified by those islands, such as tarpaulins, water, etc. A couple of our personnel would already been mobilized to join the grouping, Mr. Deputy Speaker. Evacuation efforts have been well underway. In areas of Bahamas, evacuation started ahead of Irma. In other devastated islands such as Barbuda, evacuation efforts continue. In addition to its base in Barbados, CDEMA has a support team stationed in Jamaica that is providing immediate support for the Bahamas, Turks and Caicos, and Haiti and the areas needed. CDEMA agency has also mobilized military personnel for deployment to affected islands and is in communication with Barbados, Guyana, and Trinidad for additional military support and deployment as necessary to the affected islands. It is noted in some islands like St. Martin, looting has already started some activities that sometimes occur, unfortunately. In some cases of disaster, it has brought on the best in elements in the population, but sometimes has brought on the worst in some elements. We saw it here in Grenada in 2004. A 36-man team is in Antigua and they are going to the BVI in Anguilla this morning. Water, 10 security support and needs readily identified by these islands, and we are prepared to deliver. A team of 100 persons leaving from Kingston, Jamaica this morning with first supplies of 1,000 households for Turks and Caicos Islands and the Bahamas as needed. The team includes engineers, medics, regiments, first responders. Landing is difficult, Mr. Deputy Speaker, for some of these islands. Therefore, there are logistical challenges of movement, but SEDIMA is using every option for delivery of personnel and resources, including the RSS services. Northern Haiti, we know it was flooded, Mr. Deputy Speaker, so we are working on external support for that area as well. As chairman of CARICOM, I think that SEDIMA team, I want to thank SEDIMA team for being proactive in addressing the needs of the affected islands, but I also want to express my deep appreciation to donor countries and groups for their contributions to SEDIMA so far in meeting the needs of our fellow brothers and sisters. I also would like to compliment the leadership of the OECS, Dr. Didicus Jules and his team has been working, and as chairman of CARICOM and Prime Minister Chastity as chairman of the OECS, we have agreed that to avoid any duplication of services or of resources, that both Secretariat, the CARICOM Secretariat, with the leadership of the Secretary General Loroc and the Director General of the OECS should coordinate and work very closely in ensuring that we optimize the services that we are providing. Among those groups and countries that are on the ground in Barbados at the SEDIMA headquarters are the United Kingdom, the United Nations, UNICEF, and the Food and Agricultural Organization of the United Nations. We expect more to come. The Executive Director of SEDIMA, Mr. Ronald Jackson, has assured us that even while SEDIMA works to address the needs of those islands affected by Irma, the agency is also paying keen attention to Hurricane Jose, which is expected to be Category 3 hurricane following a similar path to Hurricane Irma. The unfortunate thing, Mr. Deputy Speaker, about this disaster, it seems like every time there's a major hurricane, whether the name is a man, it usually another hurricane name, a lady name, follows. I don't know if there's some marriage involved in this process. You remember Ivan, and then Emily came immediately afterwards. And what Ivan did not do in the northern side, his wife came and took on the northern side for damages. We are all hopeful, Mr. Speaker, that we hope we won't see any more damage, because with the state of play already, it would be very difficult for us, Mr. Deputy Speaker, to have to deal with additional. But we, therefore, as you said, we pray for those islands and our brothers and sisters, and we continue to do so. I've already spoken with several of my colleague prime ministers in CARICOM and reiterated the solidarity and support of Grenada and the entire CARICOM community to all those affected by Hurricane Irma. Those include Prime Minister Gaston Brown, whom I called even before the impact of Irma, the afternoon before. Prime Minister of Antigua and Barbuda, Dr. the Honorable Timothy Harris of St. Kitts, the Prime Minister of St. Kitts, and the Chief Minister of Anguilla, the Honorable Victor Banz, and other persons in the region, Mr. Deputy Speaker. I've also been in contact with the Prime Minister of St. Lucia, Honorable Alan Chastity, as I mentioned before. Mr. Speaker, as soon as it's safe to do so, I also plan to travel with the Secretary General and a team from the CARICOM. We await word on the ground from our brothers and sisters in Antigua at this particular time. Mr. Speaker, in addition, CARICOM through SEDIMA is encouraging national utility companies to pledge their support to CARILEC That's an information I got this morning, to assist in the restoration of utility services in the affected islands. So here in Grenada, we are calling on our utility companies to pledge to come on board to help our brothers and sisters in this important time. There's an urgent need, Mr. Speaker. Grenada will help in a number of ways through monetary contributions and personnel and resources. So as monetary contributions, the Cabinet on Monday will address the specifics. But we also, having just had word from the Director General of the OECS and, of course, CDMA personnel, they're saying, when I asked this morning what areas should Grenada concentrate at just this particular time, they say the urgency right now is as much canned foods as possible. The countries close to Antigua, like Dominica, and other countries close by, Martinique and so on, they are sending ton loads of supply of water. So they're saying canned foods would be the priority for countries like Grenada at this particular time. Mr. Speaker, therefore, I just want to reiterate, this is a time for all of us to support each other. It's a time for us to pull hands together, as was done for Grenada in 2004, and we can do no less as a country. Thank you, Mr. Deputy Speaker.
Thank you very much, Honourable Member for St. George Northwest. And as Chairman of CARICOM, I want to let you know that this Honourable House applaud you and your team, CDMA, CARICOM, the OECS, for the joint efforts that you all have been making and are still making to see what assistance you can give to those islands that have been severely ravaged by HOR. I think the entire OECS, CARICOM, CDMA should be complimented for the tremendous effort that they have been making and will continue to make, to see the quick response that you have made thus far in the recovery efforts. So we in Grenada stand ready to assist our northern neighbors as much as possible. As you just said, canned food, so we are ready to make our contribution towards our neighbors who have been severely damaged by this disaster. Thank you very much,
Mr. Deputy Speaker, I just want to add one thing. I just got word that it seems like the thing is piling on. We just got word that Mexico had a major earthquake just a while ago, and it on the Richter scale, and you know what it is. 6 can do maximum serious damage. 8, I don't know if we have seen 8 before. In fact, many of the islands around there telling them tsunamis are quite possible. Many of the countries. So it seems like I don't know anyone at this point in time could say that climate change, we are not facing serious climate change. It cannot be that this world is just, all these activities are happening just without man-made activities that have brought tremendous consequences on all of us. Thank you, Mr. Deputy Speaker.
Item 13, personal explanations. Item 14, motions.
Honourable Member for St. David's.
Mr. Deputy Speaker, I stand to move the following resolution standing in the name of the Minister of Finance. Resolution for the purposes of Section 48 of the Public Finance Management Act number 17 of 2015. Whereas by Resolution number 613 of the Board of Governors of the International Bank for Reconstruction and Development, having considered the question of enlarging the resources of the bank through an increase in its authorized capital, concluded that an increase will be desirable, whereas the Board of Governors resolved by Resolution number 613 of the Board of Governors of the bank that the authorized capital stock of the bank be increased by 484,102 shares of capital stock each share having a par value of 100,000 in terms of United States dollars, and each member of the bank is authorized to subscribe up to the total number of shares set forth in accordance with paragraph 2 of the resolution number 613, subject to conditions. And whereas by resolution number 613, the government of Grenada, as a member of the bank, has been allotted an additional 142 shares, whereas Section 48(1) of the Public Finance Management Act number 17 of 2015 authorizes the investment of public money forming part of the consolidated fund, the contingencies fund, or held in a special fund, deposit fund, sinking fund, or any other fund for which provisions are made by or under an act with a bank, whether at call or subject to notice, with a bank, whether at call or subject to notice not exceeding 12 months, in deposits with the Eastern Caribbean Central Bank, or in a manner authorized for investment of property in the hands of trustees by any laws for the time being in force. And whereas Section 48(2) of the Act provides inter alia that Cabinet may, if satisfied that it is in the public interest and with the prior approval of the House of Representatives, authorize the Minister to purchase securities in any public company with money from the Consolidated Fund. And whereas the Government of Grenada proposes to purchase an additional 142 shares of stock in the bank, and whereas it is expedient that the Minister of Finance be authorized by a resolution of the House of Representatives to purchase an additional 142 shares of stock in the bank, now therefore be it resolved that the House of Representatives hereby authorizes the Minister of Finance to purchase an additional 142 shares of stock in the International Bank for Reconstruction and Development at a cost of $1,027,810.20, being United States dollars. Mr. Deputy Speaker, this resolution has become necessary because the Cabinet has decided that we want to purchase the additional shares, 142 shares, with money from the Consolidated Fund. And under this suite, the number of legislation that we passed to ensure fiscal discipline and proper management, we are obligated to come to Parliament with a resolution in order to invest this money taken from the Consolidated Fund. So this resolution here is seeking the approval of the House, because it says by resolution of the House, you must get prior approval to allow the Minister of Finance to make this investment of 1.27 million United States dollars in the International Bank for Reconstruction and Development. Mr. Deputy Speaker, this is a bank that we have benefited immensely from. It's a bank for international development, and buying additional shares in it, that is purchasing additional capital or equity in the bank, allows a greater share in the bank and therefore greater resources that we can draw from the bank. And therefore this is extremely critical. And you know, Mr. Speaker, this reminds me of a next fund that, just to draw a parallel, Caribbean Development Fund. I remember when we came into office, we had to pay 1 million and we could access up to 10 times that. You know, we were never able to access the fund because the previous government never paid the 1 million. But if you pay $1 million, you could get 10. Is it your best interest to pay the million? So, I always find, you know, so we are buying additional shares that will give us additional capital to benefit from this international bank. So it's an investment we are making. But because the money is coming from public funds or the consolidated fund to invest into it, you must get prior approval under the Public Finance Management Act, which is a new act. This was not in place before. It's a new act. See, Mr. Speaker, it is Act number 17 of 2015. 2015, new act that we put in place. All that is to ensure that in the management of the finances of the country, it is done in a transparent manner. That you come to Cabinet, the entire public will know. It will be gazetted, discussed here, gazetted, and everybody knows that now we are now purchasing an additional amount of shares in the value of 1.27 million that we are investing in this International Bank for Reconstruction and Development, which in the long term we will benefit. And therefore I commend this motion to the House.
Honourable Member for St. George Northwest, Prime Minister.
Mr. Deputy Speaker, in standing to give, of course, full support as the motion, as you know, as the member of St. David's quite rightly pointed out, was in my name. Mr. Deputy Speaker, his presentation is a clear demonstration of the cooperative spirit and the working of the entire team of our government at this time. It should be recalled at 4.5 to 5 years ago, around this time, around the same time, prior to the new general elections, instead of cooperative spirit, you had almost total destruction of the team. They were fighting galore all over the place. Today we're seeing the complete opposite. The member, knowing the tremendous amount of responsibility that they have to grapple with at this time, willingly accepted the request to lead on this particular motion at this time. It is well known, Mr. Deputy Speaker, that the whole of yesterday and this morning and up to last night have been actively involved in so many regional and international issues, which of course has impact on Grenada and of course the region as a whole. The Venezuela situation continues to be a major concern to all of us that as chairman of CARICOM, I'm actively involved. The whole issue of small states where there are a tremendous amount of resources available. We are now chairing that $10 billion program for 50 countries around the world, which is enormous potential. So when communications are before my desk on those, I can't allow it to just lay there. We have to act accordingly and have to be dealing with many issues related to this. And as chairman of the Caribbean Development Bank, continues again, Mr. Deputy Speaker, to occupy my time in very serious ways. And as we just said a while ago with the chairmanship of CARICOM and the present disaster that we are facing in the region, it's been totally occupying all my time. And in addition, locally, Mr. Speaker, the issue of the pension for workers, as we said, we're giving it absolute priority. Working with the trade union movement, and up to this morning at 7:30, we had a team meeting looking at ways in which addressing this specific problem, because as we said, we'll have to have some form, we'd like to have some form of specific resolution before a general election is called, and specifically to at least start to deal with some of the most urgent and desperate cases with the workers outside here. It's a caring government, Mr. Deputy Speaker, and we know when people are hurting, we also must be hurting in every single respect. But this motion, Mr. Deputy Speaker, is very specific, as the member for St. David's pointed out, that we, given our financial situation and the way we have managed our country, if we had not done this and be fiscally responsible, and of course making sure that we manage our affairs and that we can have surpluses to be able to do the things that we were never able to do, and to meet some of the fundamental responsibilities of government, we could not even have thought about buying additional shares in the bank, which of course will yield tremendous benefit for the country in many areas, financially and of course and otherwise. So this clearly is a demonstration that we are in fact in a position that this country has not been in for a very long time, Mr. Deputy Speaker. And as the member quite rightly pointed out, in the past, we didn't have to come to Parliament for this. We could have just done it on behalf of the country through the Cabinet and made the decision And if the Ministry of Finance had the resources, it proceeded to do so. But because of the fiscal part of the Fiscal Responsibility Act, we have put that constraint on ourselves to be as transparent as possible. This is not the Member of Parliament's money. This is the people's money. And therefore, we must inform them specifically when we're going to invest in any single serious initiative that we ought to be able to tell the people. So that is why we are here this morning, to ensure that there are more accountability, transparency, and good governance as far as this country is concerned. In the past, over the last period, 2008-2013, we heard a lot of nice sounding phrases, Mr. Deputy Speaker, about accountability, transparency, and good governance. We have seen every single rule of good governance broken. We have seen every single rule of accountability broken. We have seen every rule of transparency broken. Lands were sold, all kinds of things were sold without even members of Parliament, and I was leader of the opposition at the time, when we came into government, and as Minister of Finance, when we thought we had owned certain buildings and certain lands, they were sold to pay salaries. In other words, that was the government that was touting the whole question of accountability, transparency, and good governance. And we know the whole issue of good governance when the Parliament was prorogued, literally prorogued for 6 months, and therefore forced to have general elections because they could not go back to Parliament. So, Mr. Deputy Speaker, we have put in the constraints. We are being as transparent as possible, and therefore I'm proud to support this very important motion to help us to continue to gain more support, very soft loans and terms, Mr. Deputy Speaker, that this would afford us. And as the member quite rightly pointed out, Caribbean Development Fund, that was not used appropriately to gain further resources in the previous government. We are using it today and have used it effectively to bring more benefits and development to Grenada, Carriacou, and Peter Martin. So I support totally, Mr. Deputy Speaker, the motion that are now presented by the member for St. David's through the Minister of Finance.
Honorable members, the House of Representatives hereby authorizes the Minister for Finance to purchase an additional 142 shares of stock in the International Bank for reconstruction and development at the cost of $1,027,810.20 United States dollars. All those who have that opinion say aye. Aye. Of contrary opinion say nay. The ayes have it.
Item 15, bills.
Member for Carriacou and Petite Martinique Affairs.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, the Rehabilitation of Offenders Bill 2017 had its first reading in this Honorable House on July 12th of this year, Mr. Deputy Speaker. As a result, Deputy Speaker, I now beg to move the second reading and the remaining stages of this bill.
Honorable members, the question is that the bill be read a second time. All those of that opinion say aye. Sorry.
For the second and remaining stages. Again, it's suspended because it's been here before, the bill's been here before, so this is the second here. Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, this bill, the Rehabilitation of Offenders Bill 2017, seeks to remove certain obstacles or impediments which are encountered, Mr. Deputy Speaker, by certain offenders, especially those who have committed offenses at a very early time in their lives. Mr. Deputy Speaker, these offenders come to realize that the criminal records and the criminal activities continue to follow them in their lives. Of course, in most cases, denying them of very important opportunities, such as, of course, Mr. Deputy Speaker, employment, education, travel. And Mr. Deputy Speaker, we all know that even in menial jobs, persons seeking employment, in most cases, have to prove that they have a clean record. In the case of travel, many persons who are now seeking opportunity to go to a foreign country, maybe the United States, Canada, what have you, to better their lives, for better education opportunities, they find themselves stuck because, Mr. Deputy Speaker, they have a record. And we know that with a record, a police record, that many of these opportunities, Mr. Deputy Speaker, would not be available. So these persons who had committed some crime in the past have this burden to carry. Mr. Deputy Speaker, many countries, including the United States, the United Kingdom, Canada, Jamaica, Barbados, and St. Vincent and the Grenadines, have already initiated legislation to deal with these problems. Mr. Deputy Speaker, you know, we are a very forgiving and compassionate society. But we must agree that we in Grenada especially are very conservative when it comes to crime, especially vicious crimes, serious crimes. And so I'm sure there might be those among us, I'm talking in general, not specifically in this chamber, that might not be too sympathetic or might not be willing to support, Mr. Speaker, this principle of rehabilitation. Mr. Speaker, there are three main reasons for incarceration or imprisonment. The first of which is retribution. In other words, society is seeking to punish someone who has committed a crime. And that is the retribution, Mr. Deputy Speaker. The second reason is protection and security. Citizens want to feel safe. They do not want to know or feel that they are threatened because we have some persons who commit very serious crime walking around and walking around free. So that protection part, of course, Mr. Deputy Speaker, it is the way people feel. They feel insecure if you have criminals just walking the street. And that's the other reason for incarceration or imprisonment. The third one, Mr. Speaker, that is the subject of this bill mostly, is rehabilitation. Mr. Deputy Speaker, this principle is a person who has committed a crime and was punished, served his or her time, Mr. Deputy Speaker, and has not committed any other crimes in the interim should be eligible for rehabilitation. In other words, and rehabilitation is in our best interest as well. In other words, you don't want people going to prison and they come back worse than they went in, or become more vicious, or become more competent in the performance of crime than they were when they went in. And so rehabilitation is in our best interest because, of course, it means that people are now trying to make a new start in life. And so they should be encouraged in doing so, Mr. Speaker. But, Mr. Speaker, rehabilitation, which this bill speaks to, one might wonder, well, you want to tell me that people that commit very vicious crime like murder and rape, what have you, because they serve the time and they serve the punishment, and because they had not repeated their crimes, should be turned loose in society? But, Mr. Deputy Speaker, the essence of this is that there are certain categories of crimes that will not be eligible or entitled for the status of rehabilitation. And so if we look at Schedule 1 in this bill, we will see the list of criminal offenses that will not be given any kind of a consideration, Mr. Deputy Speaker, for rehabilitation. So, Mr. Deputy Speaker, we want to know what would be the period of rehabilitation. Of course, someone went to jail, served his or her time, comes out, and had not committed another offense. How long do they have to be in this status before you could grant them rehabilitation? This again, Mr. Deputy Speaker, is well outlined, I think, in Schedule 2 that gives you the length of time, of course, one has to be or consider on the rehabilitation list. So this says here, for instance, in Schedule 2, I think it's page 18 of the bill, the sentence: a fine or other non-custodial sentence subject to rehabilitation under this act. Period of rehabilitation for an adult is 4 years. So in other words, from the date they come from jail, they have to serve 4 years and be clean, not been committing any other crimes. And then they become eligible for rehabilitation. In the case of a child, of course, for that same offense, 2 years is the period for rehabilitation. A sentence of imprisonment for a term not exceeding 6 months, the period for rehabilitation to be considered is 6 years for an adult, 3 years for a child. And a sentence of imprisonment, that means if that's the crime you committed initially and you were sent to prison, then of course that period of rehabilitation period is 10 years for an adult and 5 years, Mr. Speaker, for a child. So the thing is, in order to be qualified, you must serve your time. Or if you were charged, if you had to pay a fine, that must be done. After you have served your time, then you have a period, based on what I've said here, you have a period of time, which called the rehabilitation period, within which, of course, you cannot commit any other crime, Mr. Deputy Speaker, and you are now entitled for rehabilitation. Mr. Deputy Speaker, what are the benefits of rehabilitation? We want to give people a second chance because, as I said, there are many youngsters who commit crime in their youthful age and probably did not understand the gravity of the situation. And so you're asking to give them a second chance. And so if someone is granted rehabilitation under this bill, there are certain rights that they now regain. Of course, the record will be spent, meaning that the record will be expunged, removed, the criminal record will be removed. And of course, you cannot use the previous conviction as evidence in any subsequent hearing where that individual is involved. So that is the first benefit. Secondly, under this act, Mr. Deputy Speaker, if you are employed or if you're seeking employment, I'm talking about a rehabilitated person now who has been granted rehabilitation status. They are not now obligated to disclose to a prospective employer that they were at one time convicted. And the employer asking any question that would force that individual to disclose that information, that is not permitted at all. So, Mr. Speaker, this bill, as I said, it has been adopted, the principle that has been adopted and legislation in place in other countries. We believe here in Grenada, if we give people a second chance, if we, of course, have mercy on these people, in the end, not only the individual will benefit, but of course, society and the country as a whole will benefit. And so, Mr. Deputy Speaker, I beg to present this bill for the second time.
Honorable Member for St. John.
Morning, Mr. Speaker. Mr. Deputy Speaker, I stand to give my support to this bill. Mr. Deputy Speaker, we know that sometimes we think that the people who are there to administer our laws are above repute and also to somewhat infallible in giving their judgments. But, Mr. Speaker, we know that the law usually leaves it, or most of it, to the discretion. And that's where the problem happens, or comes out. Because most of the time, the people that administer justice, or like judges, magistrates, most of the times they come out from a different background. So their values are different than someone who comes out from, I don't really want to use the word ghetto, or from a different standard of living. And Mr. Deputy Speaker, I am from an area which is, well, I was born in Guelph, and I've seen in many cases we have young people that make mistakes. Example, in some homes, they grow up hearing obscene language. You hear it on the streets. As a matter of fact, on my way to and from school or church in Guelph, I used to hear this obscenities more than any other adjectives. Yeah, and we hear it on television. But yet still I know people who have gone to the court and for using it in situations of anger end up with a criminal record. And then their whole life is scarred because you can't get a job on a cruise ship. You can't get a job in many places. You can't even travel. So, Mr. Speaker, Mr. Deputy Speaker, I'm very happy that this act would at least give a second chance because we know that from the Bible speaks about confession, which is an avenue to give us a clean slate with our Creator. And this bill, Mr. Speaker, would give someone, a young person, a second chance to having a clean slate within our society. Thank you, Mr. Deputy Speaker.
Honorable Member for St. Mark.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I rise in support of the Rehabilitation of Offenders Bill 2017 as presented by the member for Carriacou and Petit Martinique. Mr. Speaker, as has been well described before, certain very minor crimes that persons would have committed, especially during childhood, follows them for life and debars them or denies them from access to certain very important things in the future, like jobs and other opportunities like education and so on. Mr. Speaker, we are well aware that for most jobs now, security jobs, jobs on the cruise ship, and most jobs, they ask you now for a police record. And whatever the crime would have been, I well recall years ago, a young man was sent to prison for stealing one mango, a mango that you see on ground all about the place. I don't know if the magistrate was in a bad mood that day or if he got up on the wrong side of the bed, but I recall that for stealing a mango. That doesn't say that the person was right in doing it, and we know the issues with predial larceny and so on, but to be stamped as a criminal for life for minor things, really and truly, is very sad. And so I'm very happy that this bill is being presented today. I must say, Mr. Speaker, that our Prime Minister has been agitating for this bill. And I want to commend him for sticking to it to ensure that what we're seeing happening here today happens. And I know he would have liked to have it long before. But we have all at the cabinet level been concerned about what has been happening to our young people in terms of the sentences that are handed down for what we consider minor when we are aware that this could affect them for life. Mr. Speaker, I just want to speak on a few things because the bill speaks about rehabilitation after the crime has been committed or after the conviction. And rehabilitation is something that we as a government, as a nation, would have to take on very seriously. So many times persons go into prisons and they come out worse than they were before. And you have still a disturbingly high number of repeat offenders, just going in and out of the prison doors as though it was, it becomes a routine. And therefore, I would really like to see the rehabilitative process and the content of that in the prisons be stepped up a bit in terms of providing more persons with the competency to guide, to educate persons in terms of conduct, and to counsel them so that when they are released, they are better off. Mr. Speaker, the bill does speak to non-custodial sentences as well. And so we must not only concern ourselves with persons who would have been put into custody for the committing a crime, but also persons who may be sentenced a fine, but have that tendency, young men, young women, who are at risk out there on the blocks to commit something else for the next time to go into prison. So it behooves us as a government, as a nation, to find ways to identify those young people who are at risk and to come up with programs and projects. The churches, civil society, every one of us has an obligation to work hand in hand to rehabilitate those persons outside of prison as well as those inside of prisons. So we would like to see less going in, and we would also like to see less repeat offenders. Mr. Speaker, while Schedule 2, Mr. Deputy Speaker, Schedule 2 outlines the rehabilitation period for adults, for children, and certain criteria for whatever offense, what the length of time is. But the bill also speaks to, it is important to note that there will be monitoring of the behavior. It is important. Because not only to say, well, that person has paid their dues, so it's okay. But that person must be seen to be truly repentant, truly rehabilitated, looking to turn around and to make something of themselves, and committed not to repeat the offense or offenses that would have been committed. So we are supposed to put programs in place to assist them to turn around. But also there must be that will within them. Something must awaken the will within them so that they do not want to go back where they came from. And society would not be at fear that this person who had committed whatever offense, well, is back in the community, and to think that they would commit the crime again. So, Mr. Speaker, I am happy to see that this bill includes monitoring, investigation, the collection of information on those persons who would have committed the act. Mr. Speaker, I also just want to mention lastly, because I know a number of persons may want to speak, in Schedule 4, which speaks, no, sorry, it's not 4, I would have done that. The list where it's, yes. Schedule 1, which speaks to the list of crimes, speaks to murder, voluntary manslaughter, and it also speaks to rape. I would like to, I am happy to see rape included in that list, in the list with murder and arson and serious crimes. Because, Mr. Speaker, there is the perception, based on the way some of the criminals who commit rape are treated, that they're given what they call a slap on the wrist, a very light sentence. The bail is set at low figures, and this is not meant to criticize anyone who hands it down, but I think that the law needs to be revisited, and if we put in rape in the list, the category of murder and manslaughter and so on, that the sentencing and the treatment of these people must be reflective of their rape being in that category. I know that there has been concern raised in recent times in the nation. We have discussed this extensively in Cabinet, our concern of the incidence of rape and what we can do, and especially our women folk within Cabinet. We are having discussions as to what practical things we can do to bring psychological and emotional relief to the victims. Of course, the person who commits the crime also needs psychological and counseling, psychological support and counseling, but sometimes we forget the victims. And Mr. Speaker, I trust that, I am happy to see that this is a crime that does not qualify for the pardon and the rehabilitation. And so, Mr. Speaker, without any hesitation, I give my full support to the bill.
Honourable Member for St. Patrick West.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I rise to give my full support to this very important bill. Mr. Speaker, much has been said with regards to the reasons why certain offenders end up in prison. Some can border on the issue of triviality. It all depends on maybe the mindset of the presiding officer at the time. For example, a simple traffic violation, you might end up with your character being tarnished. As was said before, obscenity. Although we cannot condone, but yet I have difficulty with someone having their character being tarnished by way of a jail sentence because of obscenity. Although, as I said, it is not something we could condone. However, Mr. Speaker, I want to focus on the rehabilitative aspect, as I said before, because the chances of these people would be given a second chance, but the chances of such individuals ending up in prison again could be enhanced if we do not have the proper support mechanisms in society to help them. What structures are we going to put in place to ensure that young offenders who went to prison, when they come out, they are not being targeted by members of society, resulting in frustration and they're committing similar offenses again? And in this context, Mr. Speaker, I want to commend this government for the program, the Imani program, which we all know has served some of those young offenders quite well. And we have heard testimonies from various young people who were sent to prison. They came out, and because of the opportunities given to them through the Imani program for a second chance, Mr. Speaker, they are now regarded as role model for rehabilitation. And therefore, I believe the government must be commended. And even more, Mr. Speaker, when we look at the next phase, the proposed phase where we are looking at the young guys on the block coming into the program and being exposed to some of the rehabilitative, I'll call medicines. I believe, Mr. Speaker, this is highly commendable. And we need to promote, Mr. Speaker, some of the positives of the Imani program with regards to rehabilitating some of our young people and putting them back on the right track so they can become productive citizens of our society. And in this context, Mr. Speaker, I really want to commend this bill and to commend the government for promoting the mechanism through the Imani program to have these young people rehabilitated and be productive citizens again. Thank you very much.
Honourable Member for St. Andrews, Northeast.
Thank you very much, Mr. Deputy Speaker. At one time I felt, I know, normally in Parliament we talk about this side and the other side. I thought you and I were on the same side. That's the fourth time I'm trying to get your attention before you actually recognize me. Anyway, Mr. Deputy Speaker, I just wanted to lend my support to the bill as presented by the Honourable Member for Carriacou and Petite Martinique. All of us would know it's something that has been in discussion at the cabinet level for quite a while, and the issues of rehabilitating, especially our young people who have been incarcerated for very, what we may call in society, simple issues, and giving them a second chance. I just wanted to make sure that I lend my support. I think that all of the members before me did do justice to the explanation. But Mr. Speaker, I just want us all to wrap our mind around the whole issue of support. It is one thing to say that you're giving a second chance to someone because we think that for very simplified reasons they have been given a jail sentence and now the record is against them, and it can prevent that person or a number of persons from receiving or being able to continue to function well in life because of that conviction. But if we do not, as a government and as a society, recognize the need for continued support for the individuals who will be given a second chance, if our churches and our civic groups and so do not work with them and continue to support and encourage and give opportunities as well, because we can say you are rehabilitated after you have served your time, your charge has been dropped, you no longer have that stigma against your name. But the fact that you have been known to be a person that entered into prison and served a prison term, society itself may treat you in a particular way. So I think we must prepare our society, whether we need to have some forum or so, where we explain to society. Society itself must understand that we have a role to play now, after that person has been given a chance to be rehabilitated, to give opportunities to them. So I just wanted to stress that and to make sure, because it will only work to our benefit if we give the opportunities that they deserve to have after rehabilitation. We can say, okay, we expunge that from your record, but you know, there's still that stigma. No, I'm not going to hire him. He can't come into my business place. Remember, he stole once before. Remember, he stole from my partner. If that is how we will look at it afterwards, the whole bill here would be senseless. So I really do hope that the support system and mechanism is put in place that will work towards that, to make sure that this thing really, really works and becomes something of the past for our young people. Thank you very much, Mr. Deputy Speaker.
Honourable Member for St. Andrews, Southeast.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, it's quite obvious with the response around the tables, the way in which this bill touches, I guess, everybody in a real way. And in a real way, I'm quite sure all of us come across many young persons within our communities, in our constituencies, who are affected by what the current situation is. So, Speaker, the mention was made a while ago of the mango, and it brought back to me a case of a group of young guys. Normally, their activities would be smoking on the blocks and getting themselves into trouble. And, Mr. Deputy Speaker, that particular Friday afternoon, they decided that they're going to play a football game among themselves. And it so happened that the ball went into somebody's window. And that person decided that they are going to get a lawyer to put a case up against those young persons. After deliberation and discussion, and after identifying that it was not a deliberate act, one, and that these young people from a small community that I represent are young people who are not normally engaged in positive activities on an afternoon like that, the decision was taken to pay the lady for the window that was damaged. Mr. Deputy Speaker, I'm making that point to say that this could have been a group of young persons who could have landed themselves in Richmond Hill Prison with a criminal record, maybe, and at the end of the day, these are young persons who are denied future opportunities as a result. Mr. Speaker, in addition to that, I also want to make reference to so many of the young guys on the block particularly, who are making the decision that, look, I have gone down a particular path. I'm seeing a measure of hope, and I want to follow that hope that I'm seeing. So, Speaker, only yesterday a young man came to my office, young guy on the block again, and after one of those sessions we had on the block, he decided that he wants to go back to school. But he came yesterday concerned that if he has to go back to this tertiary institution, he would have to cut the locks on his head, because he was told unless he brings something medical that he would not be accepted. So, Speaker, Mr. Deputy Speaker, I'm raising those cases because these are young people who will end up where others may have ended up. if they are not given a second chance, if they are not given the hope that this bill seeks to give to them. And so, Mr. Speaker, if you ask me, I believe this bill represents hope for young people, particularly our marginalized, those on the blocks, those on the streets, those who would have found themselves in problems and believe there's no way out. The young man in prison who said, well, you know, my life is already messed up. You know, why do I need to do a O-level up there? Because when I come out, I'm not going to get a job. And Mr. Deputy Speaker, it's real. You know, the young man who completes electrical studies in Richmond Hill comes out excited that tomorrow I'm going to be able to get a job because this is a skill that is in demand, and finds himself on a job and is doing very well in the first week. The boss is impressed, and in the second week finds out that this is a young man who came from prison, and in the third week he was fired. This is a real case, Mr. Deputy Speaker. So, Deputy Speaker, I believe that this bill is timely. It's unfortunate it has not come before now, but it takes this government to introduce something like this to give hope to the young people of this country, to give a second chance to the young people of this country. And there are so many of them out there, Mr. Deputy Speaker, that we can use as verification that this makes sense. So if we speak about a young man who did not get to go to prison, but he paid $15,000 in court, and then he gets a $15,000 loan from the Ministry of Youth through the Grenada Development Bank, goes into business, and one of the first people to pay off the $15,000, those who never went, still struggling to pay off, pays off the $15,000, Mr. Speaker, and is a testimony that this makes sense, giving young people a second chance. What about the young man who actually went to prison, came out of prison, turned his life around, and is now going from school to school, encouraging young men who are given trouble in school, look, you don't want to end up where I did, and look at what my life is now. Please do not go that route. Mr. Speaker, Mr. Deputy Speaker, I am so excited about this for the opportunity it would give to young men particularly. We say young men are at risk. We say young men are not living up to what we expect of them. Mr. Speaker, I believe this is part of the answer, giving them in a real sense, because it's okay to say go to prison, serve your time, come out and do something. But how many of us in society are willing to embrace them and really give them a second chance? I believe this is really adding teeth to what we say when we say we care, when we say that we really want to give a second chance. Thank you, Mr. Deputy Speaker.
Honourable Member for St. George Notice.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I too rise to give my support to this bill as it was presented by the member for Carriacou and Petit-Martinique. But, Mr. Speaker, I do believe that we have to look deeper and we have to think deeper. And sometimes we tend to miss the boat. Mr. Speaker, I'm sitting here and I'm thinking, I'm almost thinking out loudly, how do we get to this point? How do we arrive at this point? And probably we look into our country and we're trying to make life better for everybody, those who are incarcerated, those who are not incarcerated. But Mr. Speaker, sometimes I wonder. Yes, we can say Grenada, we have a problem. And it is good to rehabilitate. But then who do you really rehabilitate? Who really needs rehabilitating? We say those that come from Richmond Hill. Can I ask the question, Mr. Speaker? What about those that come from Rikers? Or those that come from, you know, I look at a few names of some U.S. prisons. We're talking about real prisons here now.
And we know that after they serve the time, can be in England, in Canada, in the United States, or wherever, they're sent back to Grenada. Do we have the records on the kind of crimes that were committed by these offenders? What do we do with them when they come back in our society? How is it, Mr. Deputy Speaker, that we could put our people that were incarcerated here in Grenada through rehabilitation, and some of the hardened criminals, very hardened criminals that come back to Grenada, what kind of rehabilitation do we give to them? Will they be subjected to this kind of rehabilitation too? Mr. Deputy Speaker, that is a serious question that I want answered in this House here today, not only for those that are coming from Richmond Hill, but those that they send back to us. And some of the time, Mr. Deputy Speaker, our little resources here cannot deal with them, you know. But even if they have to go back, they will go back to Richmond Hill now and teach our men there and women there how to really behave in prison or in society when you come out. Mr. Speaker, I think we have a very serious problem in Grenada with this particular issue, and I believe that we need to address it, and we need to address it in a manner that will work for our country as a whole. I thank you, Mr. Deputy Speaker.
Honorable member or members, the question is that the bill be read a second time.
Mr. Deputy Speaker, I must take the opportunity to say thanks to my colleagues, all of whom made very meaningful contribution to this bill. As a matter of fact, I cannot remember the last time in this House that we had so many members participating in one particular bill. I want to say thanks for this. Member from St. George Northeast, your concern is about the ability to rehabilitate more hardened criminals than we are speaking about. I wasn't sure.
Mr. Deputy Speaker, I was talking about the rehabilitation of prisoners in general, not only those from Richmond Hill, but those that are sent back to our countries from the United States, from Canada. What do we do with those who serve their time in the United States or in England or in Canada and they're sent back to us? Will they be subject to that rehabilitation too? I do believe that they will need to be rehabilitated, because these are some of the most hardened criminals that we can find. Are they going to be rehabilitated under?
Mr. Deputy Speaker, the point raised by the member from St. George Northeast is quite an interesting one. But we've been struggling with this issue of deportation, where persons who probably spend most of their lives abroad, let's take the United States for instance, and have common violation of the law. They serve their time in the United States, and as soon as they step out of the prison, here goes the immigration, take them up with the other hand, home you go. The issue that we always argued is, well, really and truly, these people don't really belong to us because they learned the crime in your jurisdiction, not in ours. And in addition to that, what we found is that they were just sending these people without giving any notification or any details. And so we always had a serious problem in dealing with this deportation. And I know on levels of ministers and prime ministers that had been addressed, and nothing has been done. So in terms of our ability to rehabilitate those persons, I guess it depends on the crime and our resources to do so. But it is something that we have been complaining about in terms of sending back to us, persons who commit a crime abroad and persons over whom we have no jurisdiction. As a matter of fact, a lot of these people left here when they were kids, and so they have no connection with society here. And we always been asking for some assistance in dealing with that problem. So I understand what you're saying. Yeah.
Honorable Member for St. George Northwest.
Yeah. Mr. Speaker, I just want to stand to support the second reading of this important rehabilitation bill. As was pointed out by a number of presenters or persons responding, and specifically the member for St. Mark's, when she made the point that in some cases, some what you would consider almost simple, not major transgressions resulted in somebody being sent to jail, maybe by a magistrate at the time for whatever reasons, decided to do this. And she pointed out some person sent to jail for stealing a mango. Well, most of us who grew up in the countryside, if they used to jail people for mango and stealing a sugar cane, cutting a man's sugar cane, we wouldn't be here now. Most of us will not be here. And mango, that is something, you consider mango the people's property almost in those days, whether it's owned by somebody else. So clearly that didn't make sense. Well, Mr. Deputy, and I'm sure you would not be here today, Mr. Deputy Speaker, if they used to pick up people for a mango or something like this. But, you know, some incidents that really got to me over the years was, there was some cases, and one particular, a young lady whom I knew came from very humble beginning and struggled hard to make it through school, because I had to provide support and help for that individual, and whose parents basically did not give her the support, and did a number of O-levels and did very well. And she applied to the cruise ships for work, and they were ready to employ her. And she went, and she came to me for a recommendation. Of course, I gave her because I knew that she had conducted herself well. Lo and behold, she came back to me a couple of weeks later. And I said, well, you come to tell me when you're leaving. She said, no, I was turned down because the police record showed that I had some transgression. I said, what was it? She said to me, well, when I was going to school one day, a policeman confronted me on something, and I gave him some words, and he arrested me. And for that, she was convicted. She wasn't sent to jail. She had to pay a fine. But it was on her record. And I mean, I thought that was so unfair, knowing the individual, knowing what that individual have done for their own lives. And there are a number of other cases. The cruise ship case is a very, very well-known one, where a number of young boys and girls who've got their act together didn't commit any major crime and were prevented because of that blot on their record created problems for them. But I certainly believe this is long overdue, as the member for St. Mark's pointed out. And I know the member for Southeast St. Andrews have been involved in so many, I know she would have spoken about it, so many cases where she has literally saved a lot of young men who was on the wrong side on the law in many cases, and because of the work of the Ministry of Youth in giving them a second chance, they they have become almost an example to a lot of young people in setting up businesses, doing a lot of work in the agricultural sector, and really conducting themselves as model citizens. And therefore, there's no doubt in my mind the need for this is very much overdue and absolutely necessary. So I give my full support, Mr. Deputy Speaker, to the second reading of this bill.
Mr. Deputy
Honorable
Speaker.
Member for Carriacou and Petty Martinique Affairs.
Mr. Deputy Speaker, let me, of course, say thanks to the Prime Minister for this lucid intervention he has made. And of course, as I said before, for all the other persons here that have given support to this bill. I just want to make a point, Mr. Speaker, because there is some ambiguity here. In terms of expunging the record, or just sealing it, in terms of interpretation. Now, to expunge a record means that's it, it's gone. You have no ways of accessing it. Of course, that is not the intent, because how else would a judge be able to determine whether this is a repeat offender if there is no records at all? So the issue here is to make this clear that it is not meant to burn the record so it doesn't exist at all, but it's to seal it, so to speak. And that if a judge needs to make reference in order to determine, of course, a second offender, then that will be available to him. And so, Mr. Speaker, when we come to the committee stage, we'll have to make a small adjustment or amendment, of course, to the long title. Mr. Speaker, I beg to move the second reading of the bill. Mr. Deputy Speaker.
The question is that the bill be read a second time. All those who are of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
A bill for an act shortly entitled Rehabilitation of Offenders Bill 2017.
Honorable Member for Carriacou and Petty Martinique Affairs.
Mr. Deputy Speaker, I beg to move that the House resolve itself into a committee of the whole House to consider the bill clause by clause.
Honorable members, the question is that this Honorable House resolves itself into a committee of the whole House to consider the bill clause by clause, or part by part. All those who are of that opinion say aye. Aye. Of the contrary opinion, say no. I think the ayes have it. The ayes have it.
Part 2, spent convictions.
The question is that part 2 forms part of the bill. All those who have that opinion say aye. Of the contrary opinion say no. The ayes have it. The ayes have it.
Part 3, expungement of spent convictions.
Honorable members, the question is that part 3 forms part of the bill. All those who have that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
Part 4, miscellaneous.
Honorable members, the question is that part 4 forms part of the bill. All those who are of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
Schedule 1.
Honorable members, the question is that Schedule 1 forms part of the bill. All those who have that opinion say aye. Of the contrary opinion say no. The ayes have it. The ayes do have it.
Schedule 2.
Honorable members, the question is that Schedule 2 forms part of the bill. All those who have that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
Schedule 3.
Honorable members, the question is that Schedule 3 forms part of the bill. All those who have that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
Schedule 4.
Honorable members, the question is that Schedule 4 forms part of the bill. All those who have that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
Schedule 5.
Honorable members, the question is that Schedule 5 forms part of the bill. All those who have that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
Part 1, preliminary.
Honorable members, the question is that Part 1 forms part of the bill.
Mr. Deputy Speaker, here I wish to make the correction, actually a substitution. Oh, I'm sorry, in committee, sorry. Yes, Mr. Chairman, I want to make the substitution here in the long title where it says, an act to make provisions for certain criminal convictions of offenders to become spent, to be expunged from the records, and for matters connected therewith. Mr. Deputy Speaker, I need to now substitute this language. An act to make provisions for certain criminal convictions of offenders to become spent, for the records to be expunged, and for matters connected therewith.
Honorable members, the question is that this amendment forms part of the bill. All those who have that opinion say aye. Of the contrary opinion, say no. I think the ayes have it. The ayes have it. Honorable Member for Curriculum and Diplomatic Affairs.
Yeah. Mr. Chairman, I beg to move that the House resumes and the chairman of the committee reports progress on the bill.
Honorable members, the question is that the House resumes and the chairman of the committee reports progress on the bill. As many have that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it. This honorable House now resumes. I have to report that the bill was considered by a committee of the whole House and passed with amendment.
Mr. Deputy Speaker, I beg to move that the chairman's report be adopted.
Honorable members, the question is that the chairman's report be adopted. As many are of that opinion, say aye.
Aye.
Of the contrary opinion, say no. I think the ayes have it. The ayes have it. Honorable member for Curriculum and Thematic Affairs.
Mr. Deputy Speaker, I beg to move the third reading of the bill.
Honorable members, the question is that the bill be read a third time. The question is that the bill be read a third time and pass. As many are of that opinion, say aye. Of the contrary opinion, say no. I think the ayes have it. The ayes have it.
A bill for an act shortly entitled Rehabilitation of Offenders Bill 2017.
Honorable member for the tongue of St. George.
Mr. Speaker, I beg to introduce for the first reading a bill for an act shortly entitled Road Traffic Amendment Number 2, Bill 2017.
An act to amend the Road Traffic Act, Cap 289A, shortly entitled Road Traffic Amendment Number 2, Bill 2017.
Honorable member for the tongue of St. George.
Mr. Speaker, I beg to move that the relevant standing orders of the House be suspended to enable the bill to be taken through all its stages at this sitting.
Honorable members, the question is that the relevant standing order of the House be suspended to enable the bill to be taken through all its stages at this sitting. All those who are of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. Member for the tongue of St. George.
Mr. Speaker, I beg to move the second reading of the bill. Mr. Speaker, this bill seeks to do several things. First and foremost, it seeks to ensure safety of our citizens while traversing the roads, and in particular, those riding a motorcycle either as the operator or as the passenger of a motorcycle. Mr. Speaker, this act has been in effect since 2001. However, today we seek to accomplish two things. One, to clean up certain areas of it with respect to language, and two, in particular, in the second clause of the Act, to allow the submission of the actual schedule that the Minister has powers to submit. So, Mr. Speaker, first and foremost, the First Amendment in Section 1 of the Act, deleting the words, "a person must not," and substituting them with "no person shall." And it reads, subject to this section, a person must not drive or ride a motorcycle unless wearing protective headgear. This is now going to be changed to say, subject to the section of this Act, no person shall ride a motorcycle unless wearing protective headgear. And Mr. Speaker, it is just a cleaning up with respect to the drafting of the Act in this section. But Section 2, protective headgear worn for the purpose of this section must have such characteristics as the Minister describes by order. And the characteristics are now clearly stated by the Minister by order, which are the various, what I would refer to as Department of Transportation specifications or standards. To name a few, the American National Standard 290 of 1971, the Australian Standard, the British Standard, two separate British standards, BS 2001 and BS 2495, or three, sorry, with respect to helmets
for vehicles, as well as Canadian, Indian standards, international standard organization, and Swedish standards, Mr. Speaker. The Minister has the authority to add additional as time proceeds. Mr. Speaker, Section 3 of the Act originally says this section comes into operation 6 months after the consent of the Road Traffic Amendment Act of 2001. Mr. Speaker, we now seek, since 2001 is long past, we now seek to have that act read appropriately, which says, a person who contravenes subsection 1 commits an offense and is liable to a summary conviction to the fine of $750 and to imprisonment for 3 months. Simply that it is law. There is no grandfather period, there's no grace period. Since 2001, it has been on the books, was supposed to come into effect 6 months after 2001. So now that we are going back in to address it, we are simply saying it is law. And it is an offense, Mr. Speaker. So those are the 3 clauses here that are being addressed, and it is long overdue, I believe. I am glad to be part of a parliament, of a government that can sit regularly, that can address the issues of safety of the people, of rehabilitation, as we have done in the past, of various other issues, Mr. Speaker. But, Mr. Speaker, I also think that it is appropriate that we make sure that certain laws are enforced that in particular apply, and I believe this one does, apply to our youth who are riding scooters and who need the guidance of law in some cases to make sure that safety standards are adhered to make sure that we recognize that we are all mortal beings, and sometimes accidents, unintended, lead to irreversible circumstances of maiming or worse, death, as we have seen. So, Mr. Speaker, I look for the support in the passage of this bill. I know one of the members in particular was overly anxious and was looking for it last week, and I'm sure he will give support to this bill this week. Thank you, Mr. Speaker.
Honourable Member for St. George Southeast.
Thank you, Mr. Speaker. Mr. Speaker, I rise to give my full support to the second reading of this bill as presented for the member for the town of St. George, Minister for Health and International Business. Mr. Speaker, the amendment being made today satisfies a lot of requirements that are being called for by many of our inhabitants. And it brings us up to speed, Mr. Speaker, in some ways with respect to improvement in our safety on the road. So, Mr. Speaker, I just wish to remind this Honorable House and the nation in particular that Section 72 of the existing bill requires that a motorcyclist or a motorcycle, there should be no more than 2 persons on a motorcycle. Some of us do know, some of us don't. And sometimes we joyride with 3 and 4. This is prohibited, Mr. Speaker. It says that you must not ride your motorbike or bicycle holding on to a moving vehicle. Some of us still do. Mr. Speaker, the important point here is that these restrictions have to it a fine if you're convicted. However, if you do not wear a helmet, there was nothing to say that you will be penalized. So there was a prohibition against riding without a helmet. But how can we enforce it? No fine. $500 to fines or imprisonment for 3 months already on the book, Mr. Speaker. And we must remind people also that the law prohibits persons in the front seat from driving without a seat belt. And the fine is this, $1,000 and imprisonment for 3 months. And/or imprisonment for 3 months. But the headgear, Mr. Speaker, had no such restriction or no such fines or punishment attached to it. But, Mr. Speaker, I wish to go further. In riding a motorcycle, yes, the head may be the most critical component. But is it the only component that normally experiences a significant amount of injury? There are other components, Mr. Speaker. And I hope today, Mr. Speaker, we look and give the minister the authority. Here, it's only restricted to headgears. The medical persons, the Minister for Health, may see persons, may know about persons coming in. The medical professional may know about persons who come in, and your head may not be damaged, but there are certain other parts. We know, and we can simply look at the records that there are other protective gears with respect to the body. And as such, I'll be recommending, Mr. Speaker, to my colleague, the presenter of the bill, that we also empower the minister to make regulations with respect to not only the head, but to other components that really experience in a more prominent way damage whenever you get into an accident with a motor vehicle. So having said this, Mr. Speaker, I commend the bill. I support the bill for its second reading.
Honourable Member for St. George Northeast.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, at this time I rise with a certain sense of satisfaction because this was the argument that was made here last Friday. But Mr. Deputy Speaker, and this was the point that I'm making, the papers were sent the Thursday afternoon before Friday sitting. So by then and now I have had time to peruse the paper, put my thoughts together, and now it is more clear in my mind. Leader of Government Business, the member for St. George South East, just made mention that we must remind people that they must have the seat belts when they're sitting in front of the vehicle. But Mr. Speaker, Mr. Deputy Speaker, who sits in front of the vehicle? How old should you be to sit in front of a vehicle? Mr. Deputy Speaker, you know sometimes it bleeds my heart to see people put their 5- and 6-year-old child in front of the vehicle. I know in certain places in the world you must be 12 years or over 12 years to sit in front of a vehicle. But in Grenada, anything goes. Then he says that, Mr. Speaker, Mr. Deputy Speaker, the member for St. George South East again says that the law states that no more than 2 persons. But who are the 2 persons? Have we ever seen that the father is driving and then the little child is sitting in front of him? 4 years old, 5 years old. Oh my goodness. Are we not protecting our children? Oh, the father might be riding and then he has a little daughter or a little son hang on to the back of him. Well, the child is a person too. But is there any age limit? Can we really tell where we're going with that? Our children should be our concern here in Grenada. Mr. Deputy Speaker, I spent 10 years in Texas. I also work with the Boys and Girls Club. And therefore, as working with the Boys and Girls Club, it was my business as a director of the club to see when I see children in certain position, I had to report to the court. And if this is taking place, Mr. Speaker, the children of Grenada belongs to the state of Grenada too. And we should seek by all means to protect them when they are put in harm's way. And if they're riding on a motorbike, depending on the age, we should arrest that issue. If they're riding in the front seat of a car, that issue should be arrested. Mr. Speaker, even talking about the same road safety, well, I do not think we do this here in Grenada. But I remember when I went for my driver's license, and then consequently, because I had to drive the bus, I had to do defensive driving. Do we ever have any avenues for defensive driving in Grenada? It was when that I discovered, Mr. Deputy Speaker, that if you put a child in front of a car, and all vehicles now have airbags, and the airbags, they have side airbags, they have passenger side airbags, and the airbags are deployed at a rate of 200 miles an hour. And surely that will kill a child sitting in the front seat. And a child that are under 12 years may not be able to withstand the impact because the airbag is coming off too. And so we must look at that. Mr. Deputy Speaker, there is so much more that we can include in the study of our safety for our citizens in this country. I wish that in the future, maybe more amendments should also come to consider two persons riding on a motorbike, but the age limit should be considered, and enforce here, if it is on the books, that children under 12 years old should not have the privilege of riding in front of a car because it is of safety concern. I thank you, Mr. Deputy Speaker.
Honorable members.
Mr. Deputy Speaker, the
Honorable Member for St. David's.
Yeah, Mr. Deputy Speaker, the standing orders say that does not have anything about light in it, because in the days when it was written there was no light. So he said you must stand, and the Deputy Speaker recognize you, and that is why I stand, so that you can recognize me in making my presentation. So thank you, Mr. Deputy Speaker. Well, no light. Where I stand to support this bill, because it is very important, it bothers me, Mr. Speaker, that it seems that we have to legislate people's behavior in society all the time. Where is the responsibility of the individual to protect himself in riding a motorbike? You don't ride a motorbike. This is a dangerous thing, you know. And we have to come to Parliament to say you have to wear a helmet. Or, Mr. Speaker, people must accept responsibility. Because we always have to come. Last week, the Minister of Health came in Parliament with the amount of alcohol you could drink if it tests a certain limit. So you have to regulate the behavior of people now. They say, well, if you drink a certain amount, they test you, that's an offense, and you could be penalized. Today, here again, we regulated behavior by saying, if you're riding a motorbike, you must wear a helmet. As the representative of South said, what about the knees? To me, the part I exposed it was the knees. So do we have to come to Parliament and make an amendment and say what's our protective gear for the knees next? You don't think that is the responsibility of people? You're riding a bicycle, protect your knee and protect your head. Mr. Speaker, it's amazing, but perhaps that is how society is evolving, where governments all over the world have to pass law to tell people how to behave, I mean, in society. And so we are here today, and I commend the bill because I look at over the holiday period with these bikers going around the island, and I calculate roughly about 25% of them did not have any helmet. And then when I spoke to one of them, they said the law does not require them to have you waiting on a law to come before you put a helmet to protect your head? I think we need to be serious. I mean, let people take responsibility for the action, and since they are not doing it, then we have to come with legislation and with fine, with penalties for breaking the law to get people to comply for their own safety. See, that is what we have to do, and therefore I commend this bill because it's important that we put it into law, because if you don't put it, then you do not get anybody, or you do not get somebody, bikers, to wear the helmet. And so I'm happy to see that we have it now in law that can be enforced with a penalty. Thank you, Mr. Deputy Speaker.
Honourable Member for the Tongue of St. George.
Mr. Speaker, I rise simply to thank my fellow colleagues for the support in this bill, and also to recognize the passion with which they spoke, in particular the member from St. George Northeast, specifically to road traffic, and introducing some other points, as well as the member for St. George Southeast. Other points that could be considered as we move forward, and I think ably I would like to suggest that maybe they lead the charge on looking at further amendments that can be considered within the Road Traffic Act, not just what we are looking at today and what has been suggested for variance possibly in committee today, but additional areas to improve road safety in general. We are all members of this honorable House, and all have the right and the ability to seek to amend an act like this. Thank you, Mr. Speaker, and I look forward to the second reading of this bill.
Honourable members, the question is that the bill be read a second time. All those who are of that opinion say aye. Of the contrary opinion, say no. I think the ayes have it. The ayes have it.
A bill for an act shortly entitled Road Traffic Amendment Number 2, Bill 2017.
Honourable Member for the Tongue of St. George.
Mr. Speaker, I beg to move that the House resolve itself into a committee of the whole House to consider the bill clause by clause.
Honourable members, the question is that this House resolves itself into a committee of the whole House to consider the bill clause by clause. All those who are of that opinion say aye. Aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it. This honourable House is now in committee.
Clause 2, Amendment to Section 74 of Principal Act.
Mr. Deputy
Honourable
Chair,
Member for the Tongue of St. George. I'm proposing
an amendment, Mr. Speaker, to Section 74, amendment to Section 74 of the Principal Act. And I'd read out this, Mr. Speaker, the draft to take care of the wider environment for safety, because we talk about headgear, we talk about gears to protect the knee, and pretty soon I think they'll be coming up with gears to protect the elbows. Apparently these are the major components and parts of the body that suffer. And the amendment proffered, Mr. Speaker, is protective gear. Amendment to Section 74 of the Act is repealed and the following substituted. Therefore, protective gear 1, 74.1, subject to this section, no person shall drive or ride on a motor vehicle unless wearing protective gear designed to protect the person driving or riding on a motor vehicle. So, Speaker, we now are no longer talking about headgear only. We're talking about protective gear. And 2, protective gear worn for the purpose of subsection 1 shall have such characteristics as the minister prescribed by order. So the difference here is simply a removing of headgear and talking about protective gear. So if, as working in conjunction with the police, who must be complimented, Mr. Speaker, because they played a significant role in the road traffic amendment that we have before us. If we come forward and at a point in time they decide now it's a time we must go with the knee protection, then we can do it. No, we cannot do it. You could only prescribe for the headgear. And item 3, we propose a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine of $750 and to imprisonment for 3 months. You see, these two things are the A and B. Mr. Speaker. So this here, what it does is to remove the restriction on headgear and make it wider, broaden it to protective gear. It's for the same persons riding the motorcycle. Unfortunately, I don't believe that without the involvement of the police again, that we could move at this stage with putting an age limit of the child, because you'll have to who in the front of a vehicle or who will be riding along with the parent on the car, like the little child that the member for St. George Northeast spoke about, hanging on to the backs of his father or mother, because women do a lot of riding these days. I think this could come later, and we must involve the police in this. So I think this, Mr. Speaker, will broaden the safety aspect, and as we go forward, we'll take it. So perhaps I'll pass this to the amendment to the clerk, unless the Speaker would want me to repeat it verbatim so that the officers can write it down. So should I repeat again? All right.
Chairman, sorry. If I can just confirm, Member from St. Mark's, you had a comment. That all we are doing now is removing the word head. That's all from what was previously circulated, which would give the minister in future, not now in this passing or this iteration, in future to address protective gear as opposed to having to come back to Parliament to amend. We're not saying that we have intention right now of passing additional regulation with respect to protective gear, but we want to be forward-thinking and remove the word head from protective headgear as it applies in the amendment now for future reference.
So, Mr. Deputy Speaker, I think the officers have the direct contact with the legal persons, so maybe we could just pass the document to them. And if I could just repeat it, if you so wish.
Thank you. No,
Honorable Member for the tongue of, for St. Mark.
Yeah, thank you, Mr. Chairman. Mr. Chairman, I just have a concern as to how far it would take us if we just put protective headgear and do not put on specifically what we're referring to, because then it seems to me that it will be up to the discretion of the policeman, of the traffic policeman, or whoever is dealing with the offender at that time. How do we minimize this? That's what it seems to me. If you just put protective gear, and while it may be very useful to look at other areas like the knee or so, I am just asking, is it necessary at this time that we make it onerous and problematic for compliance?
Mr. Chairman. Mr. Chairman, I agree fully.
Member for the tongue of St. George.
Chairman, I agree fully with the member for St. Mark's. That's why I'm saying I wanted a clarification. According to the current act that we would be amending, protective gear worn for the purpose of of subsection 1 must have such characteristics as the minister prescribes by order, and that we are agreeing now the only order being prescribed is helmet. That is the only order that the minister is prescribing right now, and that the minister has to prescribe in the future the quality and type of any other additional headgear. It is not right now for the police to decide what is protective. Only the minister can give the police the authority to enforce what is protective gear that is required. And I am only agreeing to this amendment too under the understanding that the only protective gear that we are considering at this point in time is helmet, because I am unaware of any other jurisdiction internationally that has a law requiring additional protective gear for riding a motorcycle as being law, but that we want to be able to follow as quickly as possible should there be an acceptable additional standard or requirement without having to come back to Parliament. So that's why I'm agreeing to. So I support you with that. I don't want to complicate this. We came here today to enforce helmets, and I expect that we're leaving here today with only the enforcement of helmets, but the ability not to have to come back to Parliament and amend an act should we want to adhere to new international standards that additional gear is required.
Mr. Chairman.
Honourable Member for St. Mark.
I just want to suggest then, in light of the fact that other forms of protection may be considered at some subsequent time, that the member for the town of St. George undertakes as Minister for Health some serious data collection in terms of injury to other parts of the body, in terms of cost, whether it's monetary cost or cost in terms of pain and loss of limb and loss of use, over a period of time, so that it would inform any additional inclusion under protection, and so that whatever decision is made, it is made based on sound data. Thank you, Mr. Chair.
Mr. Chair, Mr. Chairman.
Honourable Member for the tongue of St. David. For St. David, sorry.
Yeah, we don't have a tongue yet, Mr.
I know, sorry.
But I just want to be very clear, because what the Leader of Government Business read as the amendment gave me the impression that we were removing helmet and to expand to say protective gears. So I just want to be sure, because that is what my understanding was from what was read, that you remove, you don't use the word head protection, you replace it now and say protective gears. I want to ensure that we leave helmet or head protection and say including any other thing. So I want the Leader of the Government's Business or the member from the tongue to please clarify that, because I want to ensure that we have the headgear to include others, because that's not how the amendment is read.
I too would like this matter to be clarified so that we make a unanimous decision as to exactly what we want in this act. Leader of Government Business.
Thank you, Mr. Deputy Speaker. I think all the comments made are extremely valid, in the sense that protective gear must be defined. Because if you don't have a shot, and then the police will say, well, that's a protective gear, you go to say, right? And if you don't have a ring on your finger, then you could say that's a protective gear. But I'm reliably advised that the second clause, which says protective gear for the purposes of subsection 1. So wherever you see protective gear, shall have such characteristics as the minister prescribed by order. So when you have protective gear, it is not loose. It has to be prescribed. And I think it's very good. If the members wish that it could even go further, I mean, the legal draft person might say protective gear for the purposes of subsection 1 shall be determined and prescribed for the minister. If you want to make it clear. To the drafters, they're saying abundantly, this is what it means here. So we say protective gear in one. If you make an offense against a protective gear, it is not anything per se. Subsection 2 says protective gear for the purposes of subsection 1, that's you defining protective gear, shall be prescribed by the minister. Okay. So today, as it stands now, what is being prescribed is helmet. So after we meet with the police and the consultation, etc., we might do protective things for the knees. So except these two, as prescribed, the police cannot charge you and say you're not wearing a shoe. Maybe if we see bikers without a shoe, then we might prescribe later that you must have a shoe. And as the Minister for Labor defined, we shouldn't be telling people, they should have their own initiative and their own feeling to know that you must wear a shoe. That does not mean that you don't see people riding without a shoe. It's unlikely, but you may see it. But all these things will come. So I hope this satisfies, Mr. Speaker, because according to the drafters, they understand that you cannot leave it broadly so that you get charged for a wide range. So it's only when prescribed. The protective gear will be described.
Therefore,
Honorable Member for St. Mark.
Therefore, Mr. Chairman, my understanding is that we leave here with the understanding, and that Grenadian public, especially the bike riders, would understand that for now the prescription is limited to helmet, but that it may be extended as the need arises. So can we leave here with that understanding?
That is so, as I see. In fact, the draft order has not come into effect, as yet, because you make an order and there was nothing to push it. So the draft order on the table before says headgears, helmet. And I know that there will be consultation with the bikers, the police, and other interested stakeholders, and then we could go with, knee or any other place there.
Mr. Chairman, I have a suggestion, because I sense there's a bit of uneasiness by some members, myself included, in terms of what exactly we are amending without properly thinking it through. Having thought through previously what was tabled, this change, while I support and agree, is quite significant. It is removing Parliament and giving the Minister a lot more powers than we intended to today, without having, and remember, the Minister is not necessarily this Minister, but all future Ministers. I think let us maintain the spirit of we want to make sure that we don't have to come back consistently to Parliament for additional road safety protection, and possibly pass it over this time around in consideration that road safety with respect to, as was raised, the age of individuals that should be in the front seat of vehicles, the age of individuals that should be on a bike, etc. And let us do a thorough glance again, having now, I think today, satisfied ourselves that in the last week we have dealt with DUI, we have dealt with helmets, and we need to come back knowing that our Parliament is a regular sitting Parliament and look at it. If there is, I don't know what other members feel, if there is a certain amount of uneasiness, I do understand what this Minister is asking for and support it from the point of view of this Minister. But what we are passing will be for any other future Minister of Transport, unless otherwise varied again in a future House. So I think we need to make sure that the law doesn't necessarily apply in terms of giving the powers to a certain personality, but it gives the powers to an office, and whether we're comfortable in giving the powers to that office.
Mr. Deputy Chair, I'm surprised you're coming, because the Minister is a Minister in Cabinet. It is not this person or personality whatsoever. for an order to be prescribed, it must be approved by the cabinet. So that is one issue. And I very much respect what the minister for, or the representative for St. Mark is saying, that we have to ensure that you cannot be charged except it is specific. And I recommend this, and for clarity, maybe the terms of the word that the draft persons could put in Section 2, protective gears for the purposes of Section 1 shall be prescribed and have such characteristic as the minister is by order. So to make sure that it's prescribed and clear, so maybe you could get a draft in that context. Again, Mr. Deputy Speaker, the drafting unit is claiming that it is very clear here, and it is not unambiguous, that unless it is prescribed, it cannot be taken as a protective gear. So the order must say a knee protective gear, then that's the only time the police can charge you. It will say head, and that's headgear, and that's the only time the police could charge you. If you don't have a headgear, as it is now, that's all we determine. Later on, we move on with the kneecap, discussing with the bikers and the police and other stakeholders. Then you see knee protection, and these are the only two things you can be stopped for. If later on you see a ring, then these are the only three things that you'd be able to start for. So I take the comment from the member for St. Mark, and it is very clear. We need not say that you have to prescribe the gear, and then you have to prescribe the characteristic of the gear. And this is what item 2 is doing. So I recommend it.
Honorable member, the question is that clause 2 forms part of the bill as amended. All those who have that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
Clause 1, short title.
Honorable members, the question is that clause 1 forms part of the bill. All those who have that opinion say aye. Of the contrary opinion say no. The ayes have it. The ayes have it. Honorable member for the tongue of St. George.
Mr. Chairman, I beg to move that the House resume and the chairman of the committee reports progress on the bill.
Honorable members, the question is that the House resumes and the chairman of the committee reports progress on the bill. As many as are of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it. I have to report that the bill was considered by a committee of the whole House and passed with amendment.
Mr. Deputy Speaker, I beg to move that the chairman's report be adopted.
That the chairman's report be adopted. As many as are of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it. St. George.
Mr. Speaker, I beg to move the third reading of the bill.
members, the question is that the bill be read a third time. The question is that the bill be read a third time and passed. As many as are of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
A bill for an act shortly entitled Road Traffic Amendment Number 2, Bill 2017.
Leader of Government Business.
Mr. Speaker, I beg to introduce for first reading the bill for an act shortly entitled Physical Planning and Development Control Amendment Bill 2017.
An act to amend the Physical Planning and Development Control Act Number 23 of 2016, shortly entitled Physical Planning and Development Control Amendment Bill 2017.
Leader of Government Business.
Thank you, Mr. Speaker. I beg to move that the relevant standing orders of the House be suspended in order to take the bill through all stages of this sitting.
Honorable members, the question is that the relevant standing order of the House be suspended to enable the bill to be taken through all its stages at this sitting. All those who are of that opinion say aye.
Aye.
Those of the contrary opinion say no. I think the ayes have it. Leader of Government Business.
Mr. Speaker, I beg to move the second reading of the bill. Mr. Deputy Speaker, this bill seeks to make some amendments, simple amendments to the bill, and really to solve a problem that is plaguing the development, particularly the infrastructural development in our country. Mr. Speaker, as it stands now, only two persons could sign the documents to send out from the Physical Development Authority. And those persons under the Act are the Secretary and the Senior Planning Officer. Therefore, an application is made for development of a project, for permission to develop lands, buildings, etc. And if either of these persons are not available, then the document cannot be signed. You may convey to the developer that your plan is approved, but the banks do not want a word of mouth something. The bank wants a document signed by the parties. And we have been plagued with this problem, Mr. Speaker. Many developers are complaining, and we know this affects our ease of doing business ranking. And if someone has left the country for 2 weeks, someone with financing of millions of dollars could be affected, because in the agreement for financing, it says by a certain date, you will show proof of approval from the Planning and Development Authority. However, you cannot show it, and so you lose a significant amount of monies. Or you may have paid a significant sum and commitment on millions of dollars, and the time has passed, and so the banking institution, the financial institution will say, here is an opportunity for you to pay again because you did not reach, Mr. Speaker. You did not meet the time frame. So what the most fundamental amendment here, Mr. Speaker, is amendment to Section 6 of Principal Act in deleting the word head of the physical planning unit and substituting, therefore, senior planning officer and. What the law says is that these two persons, the head of the physical development unit, well, that in itself, Mr. Speaker, creates a little doubt because there is no head of physical planning unit. There is a senior planning officer. But that's how it was. So you see, we're making that amendment, the senior planning officer and the secretary. We're substituting, therefore, persons who can now sign. The secretary will sign. Why? Because the secretary can be appointed by the board. So if the secretary is out, the board of the authority can put someone else to act as secretary and they can sign the document. However, Mr. Speaker, the senior planning officer is a public service commission appointment for the time being. And if that person is out, you have to go to the Public Service Commission, and if you did not do it in time, then you would not have a replacement. And so 1 week, 2 weeks could pass administratively, and a lot of plans could suffer damage here. So the amendment, Mr. Speaker, is saying that the secretary and the chief executive officer, who is the chief person there, because we're moving into a statutory body, and the person in charge of the day-to-day operations is the chief executive officer. Or, if you still leave it as two, Mr. Speaker, whenever one is out, you have a problem. So we say it's either the chief executive officer or a senior technical employee of the authority approved by the board. Why have we removed it? Before it was the chairman and the secretary. But in discussing with the international institutions, you want to ensure that if the board says, we approve this plan subject to this technical thing being completed. Now it is a technical officer that must be able to visit the site to say that this technical condition has been met. You don't expect the chairman of the board to do it. The chief executive officer could do it, or a senior person who can do it. So if one is out, Mr. Speaker, if the chief executive officer is out, you have the senior technical person approved by the board. So if that person, that senior technical person is out, the board could approve another senior technical person. That was a real handicap, Mr. Speaker, to development. And one person seems to have all the authority, and not seems to. Even if he wants somebody else to sign for him, he can't. If he has to leave the country, there is the void. So this amendment, Mr. Speaker, and I'm sure that developers will be happy to hear it now, you no longer will be waiting on one person. Now the board can determine any two persons with the proper characteristic and qualification to sign the documents, to send it out to the banks, Mr. Speaker. The other amendments, Mr. Speaker, are very simple. We had an environmental study, but we simply want to put impact, EIA. They defined EIA as an environmental assessment, but we simply insert the word impact. Very simple, Mr. Speaker. And Schedule 1 of the Principal Act is amended in subsection 2 by deleting the word any. What is said, Mr. Speaker, is the quorum shall be any voting members. What we have inserted here, Mr. Speaker, is the quorum shall be what 6? The quorum shall be any 6 voting members. Because you do have persons who sit at the board and attend board meetings without voting rights. So we simply inserted the word 6. That was a simple omission, Mr. Speaker. And the very first one again is a simple omission. We had the word physical planning and development control is a principal act, and we say where it appears by deleting the word physical planning unit and saying that the physical planning unit means a unit, whether or not called by that name, responsible for the implementation of the act. And we had physical, in many places in the act, we had physical development, and we had planning development, but it is planning and physical development. So these are just putting some words together to make the act standard, and they are, well, not unimportant, but they are minor compared to the amendment of Section 6, which broadens the scope and leaves room now for persons not having to wait. You call the permanent secretary, she could do nothing about it because this person is out. But right now, the authority could make a statement in case that somebody is out, this is the person that will act, and you will have your documents out the next day. And so the development can proceed in a smooth manner. Mr. Speaker, I recommend this amendment for its second reading.
Honorable members, the question is that the bill be read a second time. Honorable member for St. John.
Yeah. Mr. Deputy Speaker, I rise to support the amendments in the planning bill. Mr. Deputy Speaker, we know the importance of proper planning, because without proper planning, you would have chaos. And we know that there is many cases, many example, if we go back to our good book, Mr. Deputy Speaker, we know the story of the foolish virgins who did not plan. So we want to have a division which plans properly and make sure that everything that happens coincides with the long-term objective of the nation's, Mr. Deputy Speaker, and especially now that we're talking about the 2030 plan. We want everything to flow. Because, Mr. Deputy Speaker, one of the functions of planning, or a few of the functions, is to ensure that any projects being built meets with our health regulations so that it would not cause problems that would impact our health. Also, the environment, well, it's changed now to the impact, because you need to know how would that project impact our environment. Also, the need to make sure that that project would fit into the present infrastructure, because it depends on the nature of the project. You would have to upgrade your electricity lines, your water lines, or your road, because you would have increased activities. So in saying this, Mr. Deputy Speaker, I want to show the importance of proper planning and the reason why the planning division is there. So we have, the law is that anytime you want to do any projects, you would have to get the planning permissions. So you have large projects that would impact our economy, and you also have small projects with people that have saved, they have their life saving and they now want to build a home. And if it is delayed, it could cause you severe financial distress on both fronts, because the large projects, you'll be losing money. And if it's a home you want to build, you would have to continue paying rent when you could be living in your own premises. So at present, Mr. Chair, there is only the two persons to sign, and sometimes they don't have to be available, because sometimes they could willingly not want to sign the document to hold you up for whatever reasons. So this is very vital Mr. Deputy Speaker, to ensure that we are not held at hostage at the whims of only two persons. Also important, Mr. Chair, is during the process of the construction, sometimes we know that in some areas you don't even see a planning inspector come and visit the project. And sometimes while you're doing the project, there are certain environmental things or other hazards that become exposed, but you didn't know about it in the first place. Because sometimes you could do a soil test, and the soil test show you that at that area where you do your test hole, it's okay, but a little waste from there could have been a past dump or some landfill, and it's only when you're doing the excavation or the construction you realize that. So that's why it's very important for during the construction period, you have the planning inspectors visit to ensure that what it is that you say you're doing is that you are doing with the plans, and at the same time anything else that is happening that could adversely affect it. And one more thing, Mr. Deputy Speaker, is that it should not only end there. It should continue, because sometimes after you see that the area is completed, you see some other person, they come and they put an addition, or they put a veranda or some little thing right where the sidewalk's supposed to go. So you end up with no sidewalk. And we see it happening. There were sidewalk that I used to traverse to go to when I was going up to PVC. Right now you're seeing steps there, or it's barricaded, and we have no sidewalks. We have visitors that you could see the fear on their faces when they're having to step into the traffic because the sidewalks are disrupted. And you ask, where were the planning officers when these things were happening? Why didn't they, stop it or do something about it? So this, Mr. Chair, Mr. Deputy Speaker, as I say, I support very much the amendment, and also would like to encourage the planners to be more vigilant and more efficient in signing the plans, and also ensuring that what it is that they signed is what it is that is being constructed. Thank you, Mr. Deputy Speaker.
Leader of Government Business.
Thank you, Mr. Speaker. I wish to commend my colleague, the member for St. John, for his valuable contribution and wide-ranging contribution, Mr. Speaker. He pointed out to the fact that not only planning to give someone a permission that you need persons to sign the document, but if there is an infringement and the person needs to be given a letter, a stop notice quickly before that person pours concrete. And if one of the person is out, you would not be able to give them a legal stop notice. You could talk, you could write a letter, but then it is not a legal stop notice. And so that restriction, as he mentioned, is not only for the planning permission where you can save your monies and ensure your project runs smoothly. It is to stop a lot of illegal things going on. And it's a poor person. They may not know what they're doing, or the developers may not know that he's offline. So the inspector comes, they report back, he or she reports back, and the document needs to be signed. But the chief planning officer is on government business abroad. There's nothing you could do to give him a legal stop notice. So it is very fundamental, Mr. Speaker, that we address this, and I want to thank the colleague for his support. I recommend this bill for its second reading.
Honourable Member for St. George Northeast.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I can indicate that the light was on, but maybe you did not look on both sides. Mr. Speaker, I too rise to give support to this bill, but I would raise one concern that I have, in that sometimes we always say that when we have too many hands in the cookie jar, And I would warn that we must limit to a certain extent the number of people that are made to sign certain government documents. And not only limit that, but we have restrictions in such a way that we avoid what we call in Grenada corruption. Because not sometimes for the people who sign in, but the intent of some people is to always steer our people in the wrong direction so that we have kickbacks, we have pay to go forward, and sometimes they might just wait until Brother Bowen is out and they say, okay, because we can get through, maybe just give a little something here or give a little something there by another person, then you see what. So we must warn and we must be very vigilant against interference of corruption into our system by more people coming in to sign. That's all I have to say, Mr.
Leader of Government Business.
Mr. Speaker, just permit me to make a point and expand on what the members said there. But I just want to point out that where you have the two persons only who can do it, I think this leaves more room for what he's mentioned for malfeasance and so forth. Yes? And the documents that they're signing, Mr. Deputy Speaker, are not of their own making. For example, the board makes a decision. None of these persons have voting rights, Mr. Speaker, but the board makes a decision. So it's either we could hold it back because it's only we two. That's where the problem comes in. So the person who is signing, already signing a decision made by a competent authority. And you might figure, well, that since they're not making the decision, then that should not be a problem. But as I indicated, if the document does not reach the bank, signed by these two people, and the bank has its lawyers, and they say this is not what we want, the permanent secretary can't sign this. The law says these are the persons that must sign it. So go back and get it signed. And if the person is not there, then we do have a problem. You see, I just want to point out that the problem that is identified there, that is a problem that could come mainly from having only two persons that can do it. But if you put another person, if that other person is absent, then the other person will operate. And that's what this amendment seeks to do, Mr. Speaker.
Honorable members, the question is that the bill be read a second time. All those who are of that opinion say aye. Aye. Of the contrary opinion, say no. I think the ayes have it. The ayes have it.
A bill for an act shortly entitled Physical Planning and Development Control Amendment Bill 2017.
Leader of Government Business.
Mr. Deputy Speaker, I beg to move that the House resolves itself into a committee of the whole House to consider the bill clause by clause.
Honorable members, the question is that this Honorable House resolves itself into a committee of the whole House to consider the bill clause by clause. All those who are of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it. This Honorable House is now in committee.
Clause 2, amendment of Section 2 of Principal Act.
Honorable members, the question is that Clause 2 forms part of the bill. All those who have that opinion, say aye. Of the contrary opinion, say no. I think the ayes have it. The ayes have it.
Clause 3, amendment of Section 6 of Principal Act.
Honorable members, the question is that Clause 3 forms part of the bill. All those who have that opinion say aye. Those of the contrary opinion say no. I think the ayes have it. The ayes have it.
Clause 4, amendment of section 22 of Principal Act.
Honorable members, the question is that clause 4 forms part of the bill. All those who are of that opinion say aye. Those of contrary opinion say no. I think the ayes have it. The ayes have it.
Clause 5, amendment of section 39 of Principal Act.
Honorable members, the question is that clause 5 forms part of the bill. All those who are of that opinion say aye. Those of contrary opinion say no. I think the ayes have it. The ayes have it.
Clause 6, amendment of Schedule 1 of Principal Act.
Honorable members, the question is that clause 6 forms part of the bill. All those who are of that opinion say aye. Those of contrary opinion say no. I think the ayes have it. The ayes have it.
Clause 1, short title.
Honorable members, the question is that clause 1, short title, forms part of the bill. All those who have that opinion say aye. Those of contrary opinion say no. I think the ayes have it. The ayes have it. Leader of Government Business.
Mr. Chairman, I beg to move that the House resumes and the Chairman of the committee report progress on the bill.
Honorable members, the question is that the House resumes and the Chairman of the committee reports progress on the bill. As many are of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it. This Honorable House resumes. I have to report that the bill was considered by a committee of the whole House and passed without amendment.
Thank you, Mr. Deputy Speaker. I beg to move that the Deputy Chair report be adopted.
The question is that the Chairman's report be adopted. As many as of that opinion say aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it. Leader of Government Business.
Thank you, Mr. Deputy Speaker. I beg to move the third reading of the bill.
Honorable members, the question is that the bill be read a third time. The question is that the bill be read a third time and pass. As many are of that opinion say aye. Of contrary opinion say no. I think the ayes have it. The ayes have it.
A bill for an act shortly entitled Physical Planning and Development Control Amendment Bill 2017.
Honorable Member for St. Andrews Southeast.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I beg to introduce for first reading a bill for an act shortly entitled Juvenile Justice Amendment Act 2017.
An act to amend the Juvenile Justice Act number 24 of 2012, shortly entitled Juvenile Justice Amendment Bill 2017.
Honorable Member for St. Andrews Southeast.
Mr. Speaker, I beg to move that the relevant standing orders of the House be suspended to enable the bill to be taken through all of its stages at this sitting.
Honorable members, the question is that the relevant standing order of this House be suspended to enable the bill to be taken through all its stages at this sitting. All those who are of that opinion say aye. Those of the contrary opinion say no. I think the ayes have it. Honorable Member for St. Andrews Southeast.
Mr. Deputy Speaker, I beg to move the second reading of the bill. So, Deputy Speaker, this bill, I believe, complements very well the bill that we would have passed this morning that deals with juveniles and how we are going to give them a second chance. So, Speaker, this bill speaks to an amendment, again, that confirms government's commitment to our young people, particularly those who would have found themselves in conflict with the law, and how we continue to find and create opportunities to give them that second chance, but very importantly, to protect them at the same time. So, Deputy Speaker, I think it's relevant to give a historical perspective of this and to say that the original, the Primary Act deals specifically with government and our society and everybody involved finding means and ways of protecting, as I said before, juveniles and young people who come into conflict with the law. However, Mr. Speaker, I want to just make the very important point that the application of criminal responsibility acts, assessment of a child, court proceedings, sentences of the child, legal representation, all of these things are captured in the Act of 2012. Mr. Speaker, it means, therefore, that while all of these were being deliberated on in this very House, while all of those important decisions were being made, we still faced the challenge that our young people were being sentenced and sent to Richmond Hill Prison, even when this very act was passed in 2012. Mr. Speaker, historically, I recall just about 2007, and many of us would recall the cry by opposition forces, the public at large, television, radio, social media. Everybody was complaining, and rightfully so, that we ought to do better in terms of protecting our young boys and girls who are being sent to Richmond Hill. Mr. Speaker, our government, we felt that it was not enough to just pass legislation. We felt that it was not just enough to say we are looking into it, we are going to do something, but we felt that we had to make that bold step and to take a decision to build a facility that we can use as a home for these persons during their rehabilitation. And so, Mr. Speaker, in 2007, under our previous NNP administration, the construction of a youth juvenile facility center started in Grand Bacolet in St. Andrew. Mr. Speaker, I don't want to go too far into all of the obstacles and all of the it should not be done, even when we said how important it was, and all of the things that would have led up to 2008, right after the general election, when work on that facility stopped. Mr. Speaker, work would have stopped between 2008 and 2013, when this government returned to office. Work on that facility resumed. And Mr. Speaker, happy am I to remind us today that our young persons who come into conflict with the law today are not being sent to Richmond Hill Prison for rehabilitation, but they are accommodated at the Grand Bacolet Youth Rehabilitation Center. Mr. Speaker, this government is not just about passing legislation, but actually putting structures and systems in place to ensure that we deal with the issues that we speak about. Mr. Speaker, I also want to say this, that the government, particularly through Ministry of Social Development and Ministry of Youth, continues to implement different programs aimed at providing those second chances, aimed at helping our young people to recover, to find their way, and to move on. So, Mr. Speaker, what we're going to do today is to amend that legislation, that act, as a deepening of the commitment to our children, as a deepening of the commitment to our country when it comes to our young people, second chance when it comes to our young people and providing opportunities for them. So the bill seeks to amend Section 2 of the Principal Act. It seeks to insert new sections, Section 10A, all the way up to Section 10P of the Principal Act. And it also makes accommodation for an amendment to Section 11 of the Principal Act. Mr. Speaker, as it relates to Section 2, it's a very, very simple amendment that has to do with the definitions. And of course, the Principal Act would not have then, even if the facility, Mr. Speaker, was left unattended, the bushes were growing and so on and so forth. The act at that time passed made no reference to that center. And so in the new amendments that we are making, we are going to add new definitions and to include center, which means the Grand Bacolet Rehabilitation and Treatment Center established under Section 10A. Mr. Speaker, we also have under the insertions I referred to 10A up to 10P. I just want to highlight there that the key changes recommended for insertion is that of the establishment of the Grand Bacolet Juvenile Rehabilitation and Treatment Center, and that speaks to, of course, the functions of the center, the establishment and the composition of a board, of course, all of the details that speaks to how the board is going to function, the functions of the board, the tenure, remuneration, filling of vacancies, meetings, and so on. And just to give an idea, Mr. Deputy Speaker, as it relates to the composition of the board, of course, the ministry wants to ensure that the issue of management is placed in the hands of the board. And so the composition of the board is so very critical and important and comprises that of the permanent secretary in the Ministry of Social Development, the director of the CPA, Child Protection Authority, of course, a police officer not below the rank of inspector. It also includes the Solicitor General, representation from Ministry of Youth, Education, a medical practitioner. We also have somebody recommended from a financial background. And of course, Mr. Deputy Speaker, we would want to consider a possible change during committee stage to ensure that the community is represented on that board as well. Mr. Deputy Speaker, in addition to that, we also want to ensure that as we speak to deepening the commitment, that we understand in a general context what this bill is trying to achieve. So generally, we're speaking about, in terms of what is the outcome we expect out of this change, the strengthening of the administration of the facility. So you want to make sure that we build capacity to manage the facility and its operation, to improve the quality of the oversight of the entire operation, and that is why the board is so important, because even if you have management, you want to make sure there is strong oversight of the facility. And to get professionals and members of the wider community more involved in influencing the policy of the facility. In addition to that, of course, we are looking at the day-to-day management, because the whole aim is not to have the ministry manage the day-to-day operation as is the case now. While you have a manager there, I believe because we do not have a board set up, a lot of the interaction is from the facility to the ministry, and we want to put between there a board that is quite capable of ensuring that the day-to-day operation is at the standard and the quality that is expected. Mr. Deputy Speaker, I wish to commend for second reading this bill because of its importance and because we need to make sure that we improve what we already have and to move forward. Thank you.
Honorable Member for St. John.
Mr. Deputy Speaker, I rise to give support to this bill. As the member from St. Andrews South East said, this is like a follow-up to the earlier bill that was passed. You see, Mr. Speaker, we know that sometimes in our youthful age, we make mistakes or we do things because there is a saying that age brings wisdom. So some of us who have not reached that full wisdom age, whatever time it is, and we take it that the more years that you live is the more wisdom that you acquire. So those in our society that have not reached that age, Mr. Speaker, do not have the full wisdom of what is life and the full consequences of the actions. And we know that not everyone grows up in the same environment with capable parents. We have some that grow up in neighborhoods where even in the home, it's survival of the fittest. And that attitude goes out in, with them in the schools or into society. And at an early age, they get into trouble with the law. And Mr. Deputy Speaker, what happens is that in areas where you do not have programs or facilities to deal with that young person, they go to the prison. And Mr. Deputy Speaker, you know that in there, then they meet with all the hardened criminals that have all the wisdom on how to do things that are not really conducive to having a good society. So they learn a lot of bad things there, Mr. Deputy Chair. And when they come back out, they try to practice what they learn in there, or they feel that they are smarter because they got caught the first time and now they meet with others in there. They know that how they could circumvent being caught next time. So what the society gets them, Mr. Speaker, is a smarter and more hardened criminal. So this program, or this amendment for the program, Mr. Deputy Speaker, aims to rehabilitate those persons. And by rehabilitate means that they are in an environment where they have both physical security and also adequate training and the means of being rehabilitated back, so that when they come out from that facility, Mr. Deputy Chair, they come back, well, hopefully remorseful for what they have done and educated as to the consequences of what they have done and how to avoid it, and rehabilitate back into a productive life into our society. And Mr. Chair, as I have grown up in an area where I have seen a lot of young people, even some of those that were in primary school with me, end up in prison and came back out of there with a life of what you call a revolving door, in and out. And every time they come out, Mr. Deputy Speaker, they distress the society. Because we have, even right now, people would tell you, well, when they see that person out, they say, well, you're supposed to lock your doors, because they know they're out and they don't want to be the victim before they go back in. Because that's what they were bred into. So, Mr. Deputy Speaker, we're hoping that this facility and this act will stem that problem so that any young person that make a mistake at an early age that go contrary to our laws would have an opportunity to get true rehabilitation so they could come back into this society and be productive and have an opportunity to live a successful life. Thank you, Mr. Deputy Speaker.
Honourable Member for the Tongue of St. George.
Mr. Speaker, I rise to give my unconditional support to the Juvenile Justice Amendment Act, Mr. Speaker, but also to draw attention to a point that was raised by my colleague that I think cannot be overstated, that this House, these honourable members are today putting this act forward for passage after having completed the construction of a facility for our juvenile offenders that is in operation now, that this act will help to make sure that that facility will be properly run. In comparison and in contrast, Mr. Speaker, to the previous members of the House who stopped the construction of that facility, much less getting to the point of setting up an amendment to the bill to allow the operation of, to allow the rehabilitation of, to allow the prevention of our juveniles going to Richmond Hill. And I think it is necessary, as this House serves the people, to draw that contrast, to show that these members not only talk the talk but walk the walk, have completed the facility and have put into, as of today, from our responsibility in the lower house, put into action the legal structure for its continuation beyond, as opposed to others who refuse to have it completed, stopped the construction, and made comments on the outside that clearly said that they were not interested in that and didn't see it as a need of the people. Much less the fact that they could not come together as a group to sit in this house, to serve the people, but instead use this house to serve them. So, Mr. Speaker, I think it is necessary to draw that. It is necessary to show that today there are two acts that I think fall hand in hand with each other. The Rehabilitation of Offenders Bill, as well as this Juvenile Justice Amendment Act, that shows we have an idea of the bigger picture of what is true governance, of what the people truly desire, and what is meaningful representation for the people. So, Mr. Speaker, I give full support to this. I think my sister has eloquently described the relevant parts of the bill. But I want to speak to the human aspect of that and what it means to be a representative in this House, in this Parliament sitting, to have not just action but pro-action, positive action for the people. Thank you, Mr. Speaker.
Honourable members. St. Andrews, Southeast.
Yeah, Mr. Deputy Speaker, just to express appreciation for the support by the members before, and just to add and conclude, Mr. Deputy Speaker, the importance of the support from not just members of government as it relates to what we're doing here, but the support of the general public for the important work that is being done at that facility and the important service that is being offered. Because if we don't take care of these young people now, we are going to take care of them at some later stage because of the additional discomfort and the additional problem they are going to cause within our society. And so I'm so happy that this would move to second reading.
Honorable members, the question is that the bill be read a second time. All those who have that opinion, say aye. Aye. Those of contrary opinion, say no. I think the ayes have it. The ayes have it.
A bill for an act shortly entitled Juvenile Justice Amendment Bill 2017.
Honorable member for St. Andrews Southeast.
So, Speaker, I beg to move that the House resolves itself into a committee of the whole House to consider this bill clause by clause.
Honorable members, the question is that this Honorable House resolves itself into a committee of the whole House to consider the bill clause by clause. All those who have that opinion say aye.
Aye.
Those of the contrary opinion say no. I think the ayes have it. The ayes have it. This Honorable House is now in committee.
Clause 2, Amendment to Section 2 of Principal Act.
Sorry. The question is that Clause 2 forms part of the bill. All those who have that opinion say aye. Aye. Of the contrary opinion say no. I think the ayes have it. The ayes have it.
Clause 3, Insertion of new sections 10A to 10P to Principal Act.
The question is that Clause 3 forms part of the bill. All those who have that opinion say aye.
Mr. Deputy Chair. Yes, Mr. Chair, I did make reference while I was presenting the bill to the House that we would want to consider a change as it relates to the section that speaks to the board, the composition of the board, which is section 10C, establishment and composition of the board. And reference is made there to one person from the community, and we would like to consider, I would want to propose that we consider making that two persons as opposed to one person. And also to add the Director of Juvenile Justice. That would have been an omission.